All right. Well, thanks, Anita. Everyone, my name's Phil Truax. As Anita said, I'm an attorney in Ohio, outside of the greater Cleveland area. Been practicing law for about 20 years. Have a small law firm of about 5 lawyers in the greater Cleveland area where we focus on representing small businesses. Our law firm does a lot of work in the construction industry. So we represent a lot of contractors, suppliers, vendors, some property owners that get involved in construction. And then we have some other businesses, miscellaneous categories of businesses. And a lot of the work that we do overlaps with a lot of the topics that we're going to review today. This is a seminar that's not intended to go too deep into the weeds on a lot of the things that we're going to discuss because there's a lot of content. The idea here is to make you more aware of legal issues that you're going to run into when you're operating your small business, and at least just have these things on your radar to really limit the landmines that are out there. We don't want you out there so focused on your own industry, the business that you've chosen to go into, and then you're completely unaware of legal risks, challenges, problems that you just walk right into them. So that's really the goal for today. And some of the takeaways that I think are going to come from today's seminar is that number one, you're going to make sure that you have a trusted advisor, a trusted legal advisor that you can rely on going forward. And two, that you're not afraid to contact them. Lawyers do cost money, but a lot of things in business cost money. And the best time, the cheapest time to hire a lawyer is before the problems start. So that's kind of my pitch for lawyers generally. I know we have people from all over the country today, which is exciting. So that's another reason why we can't, by the way, get too deep into the weeds because there's a lot of variations in the law. My law firm, we have lawyers that are licensed in Ohio, Kentucky, and New York, with experience in other states as well. But I know we've got people from all over the country. So let's jump right to it. I will go ahead and share my screen to the slides, and we can jump right in. Obviously, we have our title slide here, and I will do my best to address any questions or comments as they come up. But it's going to be, I'm going to try to keep us on task also to stay on topic. And I can see one question there of baseline costs for creating agreements, and I'll try to address that as we get closer to the section about contracts that we're going to talk about. But as you might imagine, the cost varies. But we'll talk about that a little bit more. So let's go ahead and dive right in. So here's an overview. Here are some of the things that we're going to talk about. Business entity selection. If you haven't already selected the type of business, the LLC, corporation, partnership, different types of partnerships, we can talk about that. Do you have business partners? Do you want business partners? What are some variations of having partners that in your business? Are you involved in a franchise, or is your business a independent model? You're not affiliated, associated with a larger national business like a franchise might be. We'll talk about that. Site selection, your office, your equipment yard, your warehouse. Maybe you're just working out of your home, and that may be the case for the foreseeable future. Do you have a lease? Do you own property? So on. General contract issues. This really, my personal forte is we're doing a lot of work with contracts and helping clients to really understand how important contracts are. And then intellectual property issues. I know just enough to be dangerous, as they say. My law firm does not typically get involved in intellectual property with the exception of trademarks. But it's a good primer to make you aware of the different types of intellectual property issues that are out there, and it's not just patents and trademarks. So moving to our first section is business entity selection. On board there are some examples of what business entities there are. A sole proprietor or a sole proprietorship, that is a um, that is where you do business only under a DBA. So Phil Truax forms a trucking company called PT Trucking, but I don't form an LLC or a corporation or a partnership. I'm just operating my trucking company under a trade name. That is a situation where you don't have a separate entity. You are just doing business under your personal name. Sometimes that's okay, but a lot of times that subjects you to personal liability to your house, to your car, to your boat, to your bank accounts, to your investment accounts. So one takeaway that you should seriously consider is that if you are not operating out of an LLC or a corporation or some other business entity, that you get the guidance needed in your state in order to form an entity. It is not expensive. It usually costs a filing fee of around $100 to file an LLC. And if you're the sole owner, you don't even need a operating agreement or a set of bylaws. You should look into that as you move forward, but just simply forming the LLC, getting a federal tax ID number, which is like the social security number for the company, and then opening a bank account under your new LLC, your corporation, your partnership. It's an easy process. And even if you hire a lawyer to help you, which you should consider, it doesn't cost very much money and it's absolutely worth it. So that's one kind of pitch toward business entity selection, is making sure that you have a different legal person that is your business, a legal person being that LLC, that corporation, and keeping it separate from your person, your own individuality, your family. You want to really protect your personal assets, your family, as much as possible when you're going into business for yourself, as much as you can. One quick note there at the bottom is the Corporate Transparency Act. Some of you may know about this. Some of you may have heard about it. There's also BOI, which is exactly related. BOI is building ownership or business ownership information. And it's all part of the Corporate Transparency Act that was passed last year, which was intended to cause owners of companies to make filings with the federal government to disclose your ownership interests or control interests of businesses to the federal government. That law is, for the lack of a better word, on pause. There's a current deadline of March 21st which of course is 3 days away, of making the necessary filings, but the federal government has recently come out and said they are not going to enforce any penalties for people who do any filings after March 21st. And there's been indications by the federal government that they're actually going to change the law, and they're going to extend the date. They're going to change the law. There's 35 million small businesses in the United States of America, plus or minus a billion or a billion. That's the wrong consonant. About 35 million small businesses, and the federal government was really asking for a lot of work, a lot of drag on business owners to have this Corporate Transparency Act. I personally hate it. Um, and I don't know why folks were put in a position to have to do it, but that was the law. And now, after several different court decisions and injunctions and things like that, and now the Trump administration getting more involved, the Corporate Transparency Act is, for all intents and purposes, on pause. Make sure that you get guidance from your CPA, from your legal advisor, on understanding what the status is. You can also go on to the lawsuit. If you just Google Corporate Transparency Act, you'll be able to get taken to the Financial Crimes Division of the federal government's website, and there's pretty readily available information. But right now, please do not scramble to get any filings to the federal government under the Corporate Transparency Act, because it's not worth your time. We do have one question that's directly relevant to the current slide, which I'll address. And that is a question of what are the advantages and disadvantages of creating a holding company. Without getting too far into the weeds, if you are in a business where you're doing different things, substantially different things. The classic example is your business. You have an operating company where you're doing business. Maybe you're in construction, maybe you're in trucking, maybe you're in logistics, maybe you're in IT, and your business also happens to own property. You own property. One good thing to do is to have different entities own real estate and own the business. So you can separate those assets and protect them for the various risks that happen by owning property and operating your business. Sometimes people create a parent company or a holding company that owns both businesses. So Sally Jones does not own the real estate entity and own the operating entity. Sally Jones actually operates the SA holding company, 100% owner of SA holding company. And then SA holding company is the shareholder of the company that owns real estate and the company that actually operates the business. It's just an added layer of liability protection, so that if the operating company, for example, gets sued, if there's claims made, if there's whatever it is that could happen, if there's an accident, there's an added layer of liability protection for the individual, for Sally in that instance. You don't have to do that, but that's one reason to do it. There's also instances where maybe the holding company can offer what's called shared services. Sometimes if you own different businesses, you may lease employees that actually provide employment services to the different entities. Say in Sally's example, she's got an employee who works for the operating company, but then that person also maintains the property and maybe doing, services for the business that owns the real estate. The holding company may actually end up employing that person, and then there being some shared services, and it goes beyond people. It can be technology, it can be different, utilities and things like that. That sometimes it's cheaper to have insurance or utilities or some type of services go to one entity, and then one entity provides services to the businesses that holding company owns. What I'd tell you is, unfortunately, my answer is going to be almost the same for almost every question, and that's going to be, to learn more, you got to talk to someone, an attorney, or at least your accountant. Accountants are typically good. Business accountants have a lot of information that they can offer also in situations like this if you don't have an attorney and you're not quite ready to retain a business attorney. But you're going to want to definitely consult with both your tax advisor and your lawyer on whether or not a holding company or a parent company is the right move when you're getting involved in business entity selection. Oops, I'm sorry. For business partners, this is always a very good question. Do I want a partnership? You may own the business yourself and not have any partners. That's the case for me personally. I'm the 100% owner of my law firm. I did that because I decided I wanted to start a law firm back in March of 2021, so 4 years ago. At that time, I did not have anyone in my life who I wanted to go into business with. I wanted to do this myself. And now, after having a fairly established law firm of 4 years, I will only take on a business partner who aligns with me from a mission, vision, and values standpoint. I don't care how much business, how many clients another lawyer may have, if they don't fit with me. Just like finding a spouse, or the type of friend that you're going to go on vacations and trips with, you're not going to do that with a business partner unless they align with you in many different respects. Money can't replace that. In fact, it's pretty clear in my experience as a business owner that that's what kills businesses, is people who find partners who aren't good fits. So obviously there's other things to consider when you're going to have co-owners of a business. Partners is the common way to refer to it, but you want to be careful about using the word partners if you don't have an actual legal partnership. We mentioned up in business entity selection, partnership is actually a term of art. It's actually the type of a business entity that is different from an LLC, a corporation, a partnership, and a limited partnership is a form of a partnership. Technically speaking, LLCs, limited liability companies, the owners are called members. So you have two members of a company. They're partners, as regular people like us might tend to refer to them as, but legally speaking, they're members. Corporation, they're shareholders. Those are owners, they're shareholders of a company. And of course, shareholders for a small corporation, you're not thinking of shares of like Pepsi and Coca-Cola and Exxon and large companies like that, Google and Apple and everything else. Shareholders of just two owners of a small company that performs services to the community. Those men and women are shareholders. So, but as far as having multiple owners, multiple partners, these are other examples of complementary skill sets. Maybe someone's good with numbers and someone's good with the nuts and bolts of the business. Maybe both are good at both. You've got two sophisticated people who've been in business together. They've learned from their successes and failures. They're good at various different things. You still want to make sure that as owners that people have lanes. It's always a good idea to not have 2, 3, 4 co-owners of a company just do everything together. You want to make sure that someone's responsible for certain things, and you can lay that out in an operating agreement or bylaws or just a separate agreement, something in writing. You want to make sure it's writing, whether it's actually on paper or digitally. And then, of course, who owns what, right? That's a big one. One takeaway is to try to steer away from 50-50 partnerships. I get it that people don't want to give up that 1% of control, which ends up being majority of control. But with 50-50 can come deadlocks, which can become problematic. You can have company documents that vest the control, the voting control in certain things, and then having more big picture items like changing the operating agreement, selling assets, buying property. Those things have to be unanimous consent. So you can still have certain things that have to be decided by both partners, and then have other things where one of the two or 4 or any other even number is decided by majority vote. And then, of course, there's financial considerations. So you might have one person who owns all of the equipment and or the property, and then you have the idea person, the person who has all these great ideas and maybe has some business relationships to help form new connections. Or one person's got the cash. One person can actually infuse money into the business. The other person's the sweat equity person. There's lots of different combinations of business partners, co-owners of businesses. The two partners have to sit down and iron that out. I have all the cash. You do primarily the work in the field or the work in the garage or the work with the technology. How are we going to iron that out? Because the business needs both of us, and there needs to be some conversation about what those different contributions by the owners are worth. All these things really need to be discussed before going into business, and they need to be documented. Let's see. I'm just taking a peek at some of the questions and answers that I feel like might be a good idea to consider. Matthew's got a question here about considerations for moving an existing entity's ownership from a sole to a partnership. I think I went through some of those already in the last slide of what some of those considerations are. That kind of hits home for me, because I suspect at some point, for me to be able to viably manage my law firm, I've thought about how nice it would be to actually have a partner and be able to rely on a partner for certain things. You've got to go through these things that are on the slide right here of what those overlapping skill sets and responsibilities are, who's responsible for certain types of decision making, who's bringing what to the table, and how does that impact ownership. I've always envisioned from my personal perspective that if I bring on a partner, I'm not going to bring on a 50 or 49% owner unless the circumstances really justify it. Otherwise, I'm going to bring somebody in on a gradual basis. Maybe I'll make them a 20% owner first, and based on what they can contribute, what they can bring into the business, the expertise they have, the client base they have, whatever it might be. And then as time goes along, they either get additional equity or they have to buy in. That's not so bad. And it's not unfair to say, if you want to be partners with me, I want to have you on the team. I would prefer to have you on the team with no equity, but I'm happy to give you some equity. But there's got to be meaningful contribution. And sweat equity usually is something over time. If they want to buy in or contribute an asset, a piece of equipment, for example, then maybe that's something that can substitute for equity that they would have in the business. Franchises versus independent. I don't know how much time we really need to go into this particular instance, but franchises are obviously when there's a large entity that maybe even be a global entity, if not a national entity, that does business in several different geographical areas of the country, and they rely on small business owners to open a Wendy's, or open a hardware store, or open a whatever, a cake shop, a national cake shop, or whatever it is. And those are franchise situations. Those require typically a large fee from the business owner to pay to the franchisor, and then it typically requires a franchise agreement where the business owner who's going to start the new small business, the Starbucks around the corner, they're going to have to sign a franchise agreement that binds them to the Starbucks mothership in Seattle and requires certain covenants, certain restrictions, certain obligations, that they have to do things a certain way so that Starbucks brand doesn't become impacted adversely, problematically, because they want the business owner in Muncie, Indiana to do things exactly or very, very close to the way that Seattle wants them to do that. And that's typically laid out in an operating agreement or in a franchise agreement. There's often fees also beyond the initial investment. There's often profit sharing. A piece of the monthly, quarterly, annually profit has to be paid to the franchisor. So on one hand, you get the brand recognition. You get everything that comes along with being associated with a large, recognizable national brand, but that comes at a cost. The flip side of that is something that's independent, where I don't have a big brother that I have to share anything with. I can do everything on my own. The problem with that, of course, is you don't have the guidance. You don't have any advisors. You got to go get your own advisors. You don't have the employee handbook. You don't have the draft lease agreements that the large companies and the franchises have. So working with a franchise means you have access to more resources. You use those resources that are prepared and revised and updated over time and time again, over several different struggles that have happened under that franchise. When you're independent, you're kind of starting from scratch, and you really got to find the right advisors, your score advisor, your legal advisor, your CPA, to work through what do we need and how do we get it? And are there forms available from something that we can start with? Where do I get a handbook? Do I need to work with a lawyer to get a handbook, or can you start with a form and work and go from there? So those are kind of some examples of pros and cons of a franchise versus an independent business. Site selection. Where is your business located, from the lack of a better word? You may be working from home, but you're an all digital business. That's okay. You may need a physical presence. When I started my law firm, I knew that I needed a physical presence. I could have worked from home. I could have rented conference room space as needed. to have meetings and what have you. But I knew that I needed a physical location where people could come into my office and meet with me or meet with what would become other lawyers at my firm. And you have to make that decision of what works for you. Obviously, if you're working in equipment, if you have materials, if you have equipment, you're going to need a separate office space. And then you've got to make the determination. Does the business lease this real property, this office space from someone else? Or do we own property? Do we want to buy property? My personal journey was to lease an office space for the plan was 2 years. And I knew that at or around the 2 year mark, I wanted to buy a piece of property and have my law office at a building that I own. And thankfully things went well enough that I could do that. And I have a separate entity that owns my business, my building, which is actually a converted pre-Civil War farm cottage. It's an 1850 stone structure that was remodeled to hold an office. And so I have a separate entity that owns that building and has an awful lot of financing to pay for this building. And then of course the law firm itself, and then the law firm leases from the entity that owns the building, which is pretty typical. But you don't have to do it that way. I could have just found a larger space and leased it and had my costs that way and not worry about the headaches that come along with owning property, because there is headaches that come along with owning property, as opposed to just having a landlord and dealing with a landlord to solve problems for you. If you, regardless of whether you lease or own property, but more often when you own property, you want to understand zoning problems, zoning issues, what is allowed by the municipality, the village where you're at. And understanding, signage, for example, that's always something. If you might be along a state highway, and if there's issues on the highway that are a state thing and not a local government thing, there's a whole bunch of real estate and regulatory issues that come with real estate that you need to be aware of when you're operating your business. And those are just some things that you should make sure that you manage appropriately and understand. If you are leasing, leases are not simple. Okay. You might have some personal experience with leases. Maybe it's from the business that you worked at before. Maybe you've leased property personally many times before, and you may be familiar with these types of bullet points. But I would certainly encourage anyone who's getting involved in leases, whether you're leasing property to someone else or you're leasing property from someone else as part of your business. This is a specialized area of law in my opinion, and making sure that you can coordinate with some type of legal counsel, because there's lots of different things that can be done. Rent can increase, common area maintenance charges can increase, and they can be based on different moving targets. So you need to be aware of what those are, who's responsible for what. Before we got on the call, Anita mentioned a situation where a business owner ran into a heating and cooling HVAC problem in their space. And because they didn't read the lease, they didn't know that they were on the hook for HVAC maintenance and replacement costs, which can be several thousand, if not five-figure problems, depending on what kind of HVAC system and equipment are in that building. So making sure that you have a full understanding of what your responsibilities are under the leases. Some landlords require personal guarantees to be executed as part of the lease. I would steer away from personal guarantees as long and as many times as you can, because you're setting up an entity that you're going to put your heart and soul into for your business, but you're also trying to keep it separate from your house, from your family, and signing personal guarantees, legally breaks that barrier between corporate separateness between your business and your person. So if you can, stay away from those personal guarantees. Contracts. Okay, so What I would say is, and by the way, Darren asks a question, why did you choose to lease to the law firm? Um, as a lawyer, I'm very aware of risks and legal risks and financial risks. And when I decided to make the investment into the property, I wanted to keep the property protected from risks that are involved in operating a law firm. I have insurance, malpractice insurance. All of you should make sure that you are properly insured with whatever the various insurances that are available to you. But it's something that I always advise to keep your real estate separate from your operating business, and that's why I personally did it. I also know that from a managing taxes standpoint, is rent and having depreciation on buildings and things like that are often helpful when you're managing your tax liability. I'm not a tax lawyer. I only know so much about taxes, but I've learned a lot in opening a business to understand taxes. And so there's a lot of benefits that go beyond simply managing risk, but also financial benefits that you're able as the owner, for example, the rent that gets paid from the law firm to the property business is there's a piece of that rent that comes to me as the property owner that is beneficial. And it's not much, but it's something, and it's some way to take full advantage of the various financial issues that comes with being a business owner, because the law firm has all kinds of expenses. Payroll is by far our largest expense. And all the law firm income that comes in has to be divvied up amongst those expenses. But when you're able to carve out a certain number a month in rent to the separate entity that owns the property, you can, within certain restrictions, you can carve that up into how much goes to the bank versus how much is left over. And of course, with your own property, you have to set aside maintenance type cash because the landlord's not going to pay it. I'm the landlord. So I have to make sure that when we have a problem, a roof problem, an equipment problem, whatever it is, we've got cash set aside that can actually properly repair and maintain the building. Jumping back to general contract issues. This right here, you can't overstate this enough, is know what you're signing, whether it's a lease, whether it's an agreement with a customer or a client, or whether it's an agreement with a vendor. You need to understand what is in that document. Ohio is much like a lot of other states, but Ohio is very strict when it comes to contracts. Ohio courts have routinely, time and time again, said they are not going to get in the way of what people agree to in their contracts, regardless of whether the court thinks it's fair or not. There are exceptions to that, but generally speaking, when two business people sign a contract in Ohio, they are presumed to have negotiated every single word that is in that document. And the idea that, well, we have a contract, I signed it, and then 2 years later, we're in a dispute, and that provision that is in our contract is not reasonable, it's not fair. That's an uphill battle in Ohio and in a lot of other states. You're far better off negotiating reasonable terms under any contract that your business enters into. And you would go a long way as a business owner to actually take the time to read these contracts. Number one, it makes you a better business owner. And number two, it educates you better to the risks that are out there. You might read an indemnification clause in a contract that your business has to sign. And as we sit here today, you may have no clue what indemnification means and what different scenarios can pop up. But if it's in a contract that you're going to sign, you're going to be more inclined to learn about what it is and ask questions about what it is and do some research about what it is. And these are things that you got to do at night when all your employees are at home watching TV after dinner, and you're the business owner and you've got to do these things on your own time to make you and your business better. Part of that is understanding contracts, because contracts will absolutely sink your business and may, if you sign personal guarantees and lose equipment and things like that, may also substantially affect you personally. So understand these contracts that you have, understand what goes into them. Many times especially when you're being hired by a customer or client, you're using their contract form. And you're going to have to read through that contract form that your customer or your client wants you to sign. This also applies when you're buying something, buying a service or a good or a piece of equipment from a vendor, especially when it's a larger vendor. They have forms. Many times, those contract forms can be negotiated, they can be revised. Sometimes, if you're just going to rent a piece of equipment from United Rental, for example, they're not going to change their form. Okay, fine. But you know what? If you don't ask, you never know. And if you don't go to someone and say, this provision that says I have to pay 24% interest if I'm late on anything after 15 days is unreasonable. I don't think I should have to do that. I plan on paying my bills on time, but something may happen where I may fall behind, and 24% interest is insane. I don't want to do that. If you don't express that, then United Rentals or whoever it is not going to change it. They might change it though if you're actually dealing with a human on the phone, in person, if you have to, in email. But we all know that dealing with people personally is a lot better than dealing with them digitally, meaning through email or text messages. For the love of God, stay away from doing business in text messages as far as I'm concerned. I know people like to do it, but things get lost in translation, and well, that's a whole nother seminar for another time, I think. But for contracting issues, you know, you should have some form of written contract with the people you do business with, even if it's the form of purchase orders and proposals, simple short documents, fine. These three things are the big three in my world: scope, price, and time. What are we agreeing to do? What's it going to cost? And when do we need it by? Those are three critical components of any contract. There's also terms and conditions. When payment is due? Are there conditions to payment? Are there insurance requirements? There's lots of other things that we could go into on what is in a contract, but you got to have good forms in both directions in your business. Both directions meaning customers on one side, vendors on the other, and you've got to understand them. You don't have to know everything about them, but you should at least understand on a high level of what you're signing. And if you don't, start learning. My practice involves a lot of contracts. Our law firm, we represent a lot of people who have contracts. And while we get hired to provide services for those contracts, we educate our clients, our customers, so they don't have to hire us every single time they enter in a contract. They make themselves better. And then ideally, we've got a sophisticated group of clients who call us when they run into something they're really not sure how to handle. This is beyond what they're comfortable with. They call us and say, hey, I'm going to send you a contract. Could you look at articles 8, 9, and 10 for me? I'm a little concerned about what this is going to do for this particular project or this particular service. And then we can narrow our review and make it more efficient for them. And our customers, our clients love that because we're trying to be flexible. You should find professional advisors that can do the same thing for you. We're going to jump in now for intellectual property issues. Again, full disclosure, not an IP lawyer, but I'll give you just a high level of certain things to review as we move forward. So first is all these three things are falling under non-disclosure issues. What would have been better for me for this top line to call this restrictive covenants. Restrictive covenants are promises where you're restricted from doing something. The three big ones are non-disclosure. I'm going to come in contact with information, confidential information of some kind that I'm not going to disclose or use in any circumstance other than in our business relationship. That's what an NDA is, or a confidentiality agreement. They're all over the place. Some of them are very straightforward. Some of them have buried terms in them. And this is a thing. Lawyers who work for other entities who bury terms in because they want to get as much control and they want to have as much teeth to things as possible. You got to be aware that that's out there. Non-compete, non-competition agreements, most common in employment agreements, but sometimes they're in independent contractor agreements where someone wants to hire your business to provide services for a period of time, and they may want you to agree not to compete with them. So you're going to provide services to me, but I don't want you providing services to my competitors. Depending on the state, that's enforceable. And you need to make sure that you understand that, because you don't want to sign a services agreement with another business and now you can't go provide your service to a competing business. And depending on what industry they're in, that could really cripple you on who you can do business with. And you don't want to do that. So you got to make sure you understand, are there any kinds of restrictive covenants against competition in contracts that you're being presented with? And by the way, it's not that hard to go through the document and find at least some of these things. And then at least you know it's there. And then you can coordinate with a lawyer to say, hey, I think this says I can't get hired by this customer's competitor. And if that's true, that would kill me. So could you help me work through this? And then you may have to actually just say goodbye to that opportunity, because there are some terms that are non-negotiable and they're deal breakers, and you need to know what those are. And if you just go ahead and sign contracts, you may sign a contract that is non-negotiable and a deal breaker, but you signed it. And now the only way to break that deal is by breaching the contract, and that causes all kinds of other problems. So the drum that I continue to beat in these types of things is making sure you understand and master your contracts. The other one's non-solicitation. Non-solicitation can come in different forms. Non-soliciting employees, non-soliciting customers, meaning in that independent contractor example that I gave you just a minute ago, maybe your new customer says, I don't want you soliciting any of my employees for at least 2 years after our business relationship ends. Okay, that's reasonable. Maybe it isn't. Maybe 1 year is more reasonable, but you need to know it's there, because the last thing you want to do is have that contract end and then you met someone with that customer and you decide you want them to come and work for you. Well, you could be violating the contract by approaching them. There's also non-solicitation of customers. So you're working with that customer, but your customer doesn't want you to take advantage of the relationship you have and then go talk to their customers about soliciting their business for whatever reason. So you've got to make sure you understand in these agreements when there are non-solicitation provisions. Patents. Okay, so patents are typically associated with inventions or ideas, machinery, software, some type of process. And if you have something that's truly unique to your business, you've come up with this idea, it may be worth consulting with an intellectual property attorney, and to determine whether or not you have any kind of patentability and whether or not it's worth exploring a patent. It's a very involved process. It takes a lot of time, but there can be something to having rights, exclusive rights over a process, over an idea, over something that is patentable under the law that can be very unique to your business. And this becomes especially helpful when you want to sell your business, because if you have a patent and you want to sell your business, or you want to bring on partners in exchange for equity and you want to drive up the value of your business, patents can be a handy way to do that. Even if you don't have a patent, but you have processes and procedures, that alone is great for the value of your business. But from a patent standpoint, there are certain, if you watch Shark Tank at all, you'll often see people come into the Shark Tank and they have this great idea and someone asks, do you have a patent for that? And sometimes they say no, and you see the sharks go, because they want to be able to, if they're going to invest in that business and you have this great idea, they want to know whether or not that idea is protected and can be used only by that business. Copyrights are typically protecting things in writing, things that are like sounds, music, art, that type of thing. Many times copyrights They do apply in businesses, but I would say that they're a little rarer as they apply in businesses. You might have certain designs that, from an art standpoint, can be copyrighted, where you're really going to usually run into copyright slash trademark issues are with trademarks when it comes to logos, when it comes to a style of font, maybe in your logo or in your slogan or whatever it is. Trademarks, you want to protect the name of your business. You want to avoid there being some likelihood of confusion. That's a term of art, likelihood of confusion. If you don't trademark your business name, or if you don't trademark that succinct slogan, someone else can use it, and then they protect it, and then they can prevent you from using that name or that logo. And I'm not talking necessarily about a slogan that is just your LLC or corporation name. If PT Trucking is the name of my trucking company and that's my logo, PT Trucking, somebody else can't come in and use PT Trucking because I own the name, because it's the name of the business is PT Trucking LLC. Unless somehow they can get a filing for PT Trucking Incorporated, and then they want to use the logo for PT Trucking. And now I got a problem, and I have to make sure my logo is different from them because they moved faster on protecting their name. So you want to make sure that you are protecting your name. There's different filing fees. There's trademark protection in certain states. You can see here in Ohio has trademark protection. There's federal trademark protection. You want federal trademark protection if you're going to do any work in interstate commerce in other states. So if you're in the digital world and you're selling stuff to other states, you need to be thinking about some federal issues, and maybe you want to have you've got a website where you sell crafts all over the country. You're going to want to make sure that you have federal trademark protection if you actually want to keep growing this thing and protect that name or that logo. And then, of course, there's social media. Almost everybody uses some form of social media with their business these days, and that's great. And you want to make sure that you want to understand how trademark impacts your use of a Facebook page, an Instagram account, a Twitter account, Snapchat, whatever you're using, TikTok, whatever you're using for social media. You need to be aware of, are you infringing upon anybody's trademark? Is anybody capable of infringing on your trademark? So licenses come in the context of using it. Licenses, the definition of a license is the right to use. So I'm having the right to be able to use a set of drawings, like plans or specifications, or even like someone else's piece of equipment, and you're using that person's, not just a rent, but you're actually using something to be able to use it several different times. And there might be a term of that license. There might be a scope of when you can, and in what circumstances you can use it, and what the terms of that are. Licensing most often comes in the situation of software, that I have a license to use someone else's software, or some other type of digital asset. And so you need to be on an understanding of what types of licensing issues that are associated with that. Here I invite everyone for questions. I'm going to kind of scroll through to see if there are any other questions that I might want to jump on now. One question I see from Darren is, will contracts override a state's position on IP? Typically not. They typically need to work together. But a contract typically cannot override what a state says is legal or illegal. And so you're going to want to make sure you get the guidance from the appropriate people to understand, how a state's law might impact or be impacted by the contract. But generally speaking, you can't design a contract to get around state law. Anita, I'll turn it over to you if there's any other specific questions that you see in the chat or otherwise, because there's a lot of them out there, and I know it's 12:53 Eastern time now.
Yeah, I know there are a lot. And some of them I think are just really specific. So I'm looking to see if there are ones that would be more general.
Yeah, I'm sorry to have to skip around
Yeah,
on some of these things, but
I think Darren, for
one, one,
instance,
here's one question Tracy Lumpkin asks about indemnification. And should this be mutual? That's a great question. Yes, your contract, number one, it's very reasonable that not just indemnification, but lots of other provisions. You know, some of you may run into contracts that require, this is really specific as it relates to insurance, but waivers of subrogation, meaning that an insurance company who has to pay something on a loss, they can't come back to the party that caused the damage. That's called subrogation. The insurance company subrogating against me because I'm the one who backed my car into the light pole and the light pole fell onto your building. My insurance company or your insurance company can't come back at me to say we had to pay $150,000 to fix that building, and now Phil, you have to pay that. That's called subrogation. Many times, depending on the industry, there's a subrogation, a waiver of subrogation, and I always want to say, well, look, I think none of our insurance companies should subrogate against us. We shouldn't have to fight off insurance companies if somebody makes a mistake. That's why we have insurance. Indemnification is another good example of if I have to indemnify you for things that I do wrong, you should indemnify me for things that you do wrong. And that's a reason that's always trying to find mutuality in contracts. That's a really good approach generally when you're reviewing and negotiating contracts.
there's one question about non-compete clauses becoming federally illegal recently. I don't believe that's true, but maybe you can address that.
Sure. So non-competes. Non-competes, President Biden passed an executive order to make non-competes illegal, but it was quickly the subject of an injunction. Business owners, I believe the National Chamber of Commerce filed a lawsuit against it on the basis that the federal government, from an executive standpoint, can't constitutionally ban contract provisions, which I think is right. I don't think that the president of the United States has the constitutional authority to say what is or isn't legal under a contract. That's a legislative thing. And so I don't believe currently there's any teeth to any federal law saying that non-competes are illegal. California, I know, is one state that non-competes are illegal, and I believe that in some circumstances, if you have a non-compete in your contract in California, you can actually be charged with a crime. So California really hates non-competes. I think non-competes personally should be used sparingly. I think that Ohio, they're widely enforceable. So total opposite from California. Ohio, you can have non-competes in a lot of situations. They still have limitations, but non-competes are okay. Different states have different, timing, like you can't compete within a year or 2 years or 5 years after a contract runs out. Every state is different. Personally, I feel like if you can protect your confidential information and you can protect your customer relationships and your employment relationships, usually you don't need a non-compete also. But there are definitely circumstances where you need to be careful if you're going to work with somebody that you don't want them taking your ideas and competing with you. And there aren't other ways to protect yourself. So, but the answer to the question is, federally speaking, non-competes are generally still enforceable.
There was one question about if I have an LLC and I want to become an S corp, do I need to start a whole new company?
So there are two there's kind of two issues there. You can have an LLC, but you can be taxed as an S corp. And that way you don't actually have to convert to being a corporation. So because an LLC, if your state honors LLCs, An LLC is really just a partnership, and the LLC is a it's taxed as a partnership. You can convert that to an S corp. I see Robin saying the question is if I need a new EIN. I don't believe so. Even if you convert your entity, you certainly don't need one if you're an LLC and you want to be taxed as an S corp. You don't need a new EIN. And I don't believe that if you are an LLC and you actually want to convert to a company, a corporation, whether it's a C corp or an S corp, you don't need a new EIN. But I think that's probably going to come down to a state specific issue too. One of the big takeaways, unfortunately, is me telling you you should spend more money hiring a lawyer or a CPA locally. But the reality is, when you're a business, you've got a budget for the professionals in your life that can give you guidance. You get great guidance from your SCORE mentors. You get good guidance from things like this, but you got to find a partner in your business, like lawyers and accountants and even insurance people, depending on your business. Insurance people can be really, really valuable. So, I would definitely encourage you. One of your things, one of your big takeaways moving forward is to find that great lawyer, accountant, insurance person who can walk with you in your journey.
Okay, I just have one client who, Shelda Paul, who's raised her hand. If you want to unmute, you can ask your question.
Okay, I did. Hi.
Hello.
I really like the way you talk to us about the business law tonight. So my question is, I'm a tax preparer, so I was doing that for 4 years so far. So, but I do some other businesses to live. So I do immigration services, and then I help people with doing paperwork something. So I have a sole proprietor. I have my IN under my name, everything under my name. So but I in the future I don't want to do all of this thing by myself, or because I know I will be busy for the next year gonna be, because I'm looking to do my bachelor degree. So I need to focus on my school. So do I have to switch from sole proprietor to LLC or corporation, or I can use the same entity if I need to hire someone else to work on my office?
If you're going to hire anybody, I would strongly urge you to form an entity and get an EIN for that entity and operate under that entity. I think that when you get into employment risks, you're going to need there's insurance and workers' comp, and there's things that are impactful. You have payroll tax responsibility. All of those things are going to they're going to increase your liability. It's great to have employees. That means you're growing, and no one should ever steer away from hiring employees, because that's how you grow and that's how you free yourself up to grow your business and to make your business better by finding good people to rely on. But it does come with risk. And, one of the first things you should do, not without knowing more, I would at least urge you to really look into forming an entity. Like I said, it's not very expensive and it's not super complex.
Okay, it's after 1 o'clock, and I think a lot of the questions really require discussion with your attorney. Phil is not here on a professional level. And so I think we're going to end there. The recording has Phil's email address, contact information. If you feel that you want to directly contact him, I believe that would be fine. But as he says, I think if you're in business, you need to have legal support in order to be effective. So anyway, Phil, thank you so much. I think you've added a lot of good information for our clients, and everybody enjoy the rest of your day. And thank you again. Thank you for attending.